The next case on the call of the docket is agenda number 23, 126432, People of the State of Illinois versus Robert Christopher Jones. Mr. Mark David Fisher. Before you begin, Mr. Fisher, I just wanted to announce that this case will be part of a series from our Illinois Supreme Court Historic Preservation Commission of Riding the Circuit. And mid-school children and high school children from the district in the second district, I guess, will be shown to them. They've already received the briefs, and they'll be discussing this matter.
Good morning, Your Honors. May it please the Court, Counsel. I'm Mark Fisher from the Office of the State Appellate Defender. I'm representing the appellant in this case, Robert Christopher Jones. The United States Supreme Court, including in Miller versus Alabama, has repeatedly stated that the Eighth Amendment must be viewed through the evolving standards of decency that mark the progress of a maturing society. As a result of the appellate court's decision in this case, those evolving standards of decency as they apply to Robert Jones came to a complete halt on the day he pled guilty in the year 2000 to avoid a mandatory life sentence. The appellate court ruled that solely by virtue of his guilty plea, he could not later take advantage of the Eighth Amendment. He could not later challenge his 50-year de facto life sentence based on the sea change in the law represented by cases such as Miller versus Alabama and People versus Buffer. This decision by the appellate court was erroneous. It violated the Eighth Amendment. It violated principles of fundamental fairness and justice. I would also submit it was illogical. For these reasons, Robert is asking Your Honors today to reverse that decision. He also asks Your Honors to remand this cause for a new sentencing hearing in accordance with the principles announced in cases such as Miller and Buffer and the provisions of 730 ILCS 5/5-4.5-105. In the alternative, because his appeal arose from the judge's order denying him leave to file a successive post-conviction petition, he would ask Your Honors for a remand for second stage proceedings, including the appointment of counsel. Now, in 1999, Robert was 16 years old, was charged with killing 2 people. At that time in Illinois, a defendant convicted of killing 2 or more people faced a mandatory life sentence regardless of age. Now, the record in this case is fairly brief, but it does indicate that Robert had no defense to the charges. Prior to the plea, his attorney explored the possibility of an insanity defense, but concluded that that defense was not viable. Consequently, had he proceeded to trial, he would have been convicted of 2 counts of murder. He would have received a mandatory life sentence. Had he entered into an open guilty plea, he would have received a mandatory life sentence. In addition, 2 things are apparent here. Certainly when Robert pled guilty in 2000, he could not have foreseen the developments in the law represented by Miller and its progeny. So first of all, he could not have known that the mandatory life sentence applied to juveniles such as himself would be held to be unconstitutional, nor could he have known that the 50-year sentence to which he agreed would later be found to be a de facto life sentence that would also be unconstitutional when applied to a juvenile unless the judge first gave serious consideration to his age and the attendant circumstances of the youth, the so-called Miller factors. Furthermore, no one in the courtroom that day could have foreseen these things. Not his attorney, not the prosecutor, and not the trial judge.
Counsel, generally, a guilty plea would waive all constitutional challenges, even those that arise in the future based upon changes in the law. Is Miller so different that we make an exception to this?
Yes, I would submit Miller is different. Miller announced a new constitutional rule, a rule that was found to apply retroactively by this court in Davis and by the United States Supreme Court in Montgomery. And in effect, there are two constitutional problems with respect to Robert's case. One, of course, is that he faced a mandatory life term but for his plea. So it was an unconstitutional sentencing scheme. On top of that, the sentence he received was unconstitutional because it was de facto life, and the judge did not have the opportunity to give serious consideration to his age or the attendant circumstances of youth.
But there's no requirement in Miller that a judge accepting a plea do that, correct?
Certainly if it's an open plea.
No, I know if it's an open, this is a plea agreement, though. There's no Miller requirement that a judge accepting a plea agreement make certain Miller findings.
No, what Miller says is that in order to impose a life sentence, including, according to this court in Buffer, de facto life sentence on a juvenile, the judge must first exercise discretion, a hearing and aggravation and mitigation, and again, consider youth and the intended circumstances thereof. That didn't happen here because of the negotiated plea. Now, the state argues on appeal that perhaps the judge exercised some discretion here. The only discretion the judge would have exercised would have been whether or not to accept the guilty plea. That was very limited discretion. Of course, in doing that, this was pre-Miller, this was pre-Buffer. The phrase de facto life sentence was not even part of our legal lexicon. So the sentence that he received was unconstitutional. The mandatory sentence he would have received but for the plea was unconstitutional. Under these circumstances is absolutely no constitutionally legal reason why his guilty plea should preclude him from later challenging his sentences. And in the briefs, I've cited some decisions, various branches of the Illinois Appellate Court who have decided this issue. Somewhat different circumstances, but involving guilty pleas and sentences that either were de facto life sentences or in some cases even the threat of a de facto life sentence or the threat perhaps of a life sentence. And in those cases, the appellate court concluded that the guilty plea should not preclude the later Eighth Amendment challenge. I would submit to your honors, these decisions were well-reasoned and they should be followed by your honors. Now, if your honors do grant relief, the second question concerns the type of relief, and that's one of the questions your honor, Justice Burke, has asked me this morning. Robert, I would ask your honors to grant one of two types of relief, that being either a new sentencing hearing or a remand for additional post-conviction proceedings. And in these guilty plea cases that have been discussed in the briefs, some of those cases have simply remanded for resentencing. Some have remanded for additional post-conviction proceedings. Now, Robert certainly acknowledges that the general outcome in post-conviction proceedings where a petition is dismissed at the first stage or relief is denied at the second stage, or as in Robert's case, where the petitioner is denied leave to file the successive petition, the general result, if that ruling by the trial judge was incorrect, the expected result is a remand for additional post-conviction proceedings. Of course, there have been some published appellate court cases where the court determined that the facts were so clear and the prevailing law was so clear that the case should just be remanded for the substantive relief requested in the petition. Generally, a new trial, perhaps in some cases, a new sentencing hearing. Here, we now know the prevailing legal standards that should apply. We know what happened at the time of the guilty plea. Robert believes that conserving judicial resources, ultimately, it appears this case is heading for a new sentencing hearing, and so that would be the appropriate relief. If your honors disagree and feel that because leave was denied, there should be second stage proceedings, perhaps other questions resolved in the circuit court before a sentencing hearing or deciding whether to proceed to a sentencing hearing, then certainly your honors could remand for second stage proceedings.
What would happen if this case were remanded for a new sentencing hearing? Would the state be able to reinstate the series of charges that were dismissed originally?
I don't believe the state would, unless the parties agreed perhaps to work out a new deal. And I acknowledge the circumstances here are very unusual. They are unique. The problem.
Why would the state not be able to reinstate the second murder charge and the other charges that they dismissed back in the day when the plea was taken? Why
well,
not?
Certainly if the plea is withdrawn, that is a possibility. Your Honor, Justice Burke raised that possibility. This court could decide, it's not the relief Robert's requesting, but this court could decide that the appropriate relief is to withdraw the plea and start over. If that were to happen, certainly when a negotiated plea is withdrawn, any agreement disappears, dismissed charges can be reinstated. And again, if your honors were to remand for resentencing or for additional post-conviction proceedings, certainly the parties could work out a different deal, which might include bringing back the dismissed counts. I would note to your honors, and I'm sure your honors are well aware, but even if the dismissed counts, even if this case were remanded and the dismissed counts could not be brought back, Robert would still be facing very serious sentencing consequences. For murder, the one count of first-degree murder, of course, the base sentence is between 20 and 60 years imprisonment. The victims in this case were senior citizens, so perhaps an extended term could be on the table. And this comes down to what the trial judge might think, but given the individuals were stabbed to death, I believe there were multiple stab wounds, perhaps the court could even find brutal, heinous behavior indicative of wanton cruelty. That would be a judgment for the judge to make. And of course, even a 41-year sentence, this court has said that is the functional equivalent of light. So very serious sentencing ramifications are still on the table, even if the additional charges could not be brought back.
And the defendant's aware of the danger he would be in, correct, on a remand?
Sure. Yes. Yes. Again, the primary relief requested is a resentencing. Alternatively, a remand for additional post-conviction proceedings. If your honors would say to me as counsel for Robert, well, we're going to give you two choices. One is to affirm, one is to force withdrawal of the guilty plea. I can tell you Robert would say, allow the withdrawal of the guilty plea. So that's certainly on the table. Robert has not requested it. The state didn't request it in the circuit court, or excuse me, in the appellate court. Counsel for the state brings that up as an option. Counsel even says it should be up to the state to elect the remedy. I think it should be up to this court to decide the remedy. I would also say to your honors that, as I mentioned before, Robert has no defense. When we normally think about withdrawing a guilty plea, although everything is on the table, all options are on the table, we think about proceeding to trial, which would be a waste of judicial resources now, just as it would have been back then. In addition, if Robert were asking your honors to withdraw the plea, I think he might be running afoul of two authorities that the state relies on, one of which the appellate court relied on. And those cases are Brady and Dingell. Now, there are other distinguishing circumstances, and I cover those in the briefs. But in those cases, sentencing laws changed for those individuals, and they responded by requesting to withdraw their guilty pleas. And the courts in those cases said there seems to be a disconnect. It seems now that you are disavowing your sincere statements made when you pled guilty that you committed this offense and that you were taking responsibility for the offense. And now you're seeking to withdraw the plea, so that's really just one of several reasons why Robert has not requested that relief. The problem is sentencing, and so that's the area that Robert has looked to. I would also mention an additional issue before your honors that was raised by the state in this appeal, in its brief, and that concerns the continuing validity of this court's decision in People versus Holman, particularly that aspect of Holman which requires a trial judge to find the minor permanently incorrigible if the judge is going to go on and impose a life sentence. The state argues that that aspect of Holman is no longer good law in light of the United States Supreme Court's decision in Jones versus Mississippi, and here the parties disagree. First of all, there's a question, where did the phrase of permanent incorrigibility come from, and what is its significance? Of course, it was used by this court in Holman. It was used by the United States Supreme Court in Montgomery versus Louisiana. The case holding Miller applies retroactively. But very similar phrases were used in Miller. Irreparable corruption, irretrievable depravity. Those phrases were repeated in Montgomery. I would submit they are interchangeable phrases, and their significance is they describe the type of juvenile who perhaps should receive a life sentence, on whom or for whom a life sentence would be constitutionally proportionate, in contrast to the juvenile offender whose criminal conduct is the product of transient immaturity. In other words, the juvenile offender who can grow out of it, so to speak, and who can be rehabilitated. In Miller, the court said that most juvenile offenders, in its belief, can be rehabilitated in contrast to many adult offenders. For that reason, life should not be mandatory for a juvenile because it would take in many of those juveniles who can be rehabilitated, who should not receive life sentences, for whom a life sentence would be unconstitutionally disproportionate. And Jones basically reaffirms the principles set forth in Miller. So I think the clear takeaway from Miller and from Jones and from Montgomery is the expectation that life sentences will only be imposed relatively rarely on juvenile offenders because most of them can be rehabilitated. If they can be rehabilitated, the judge needs to be able to hold a discretionary sentencing hearing to come to that conclusion. And if they can be rehabilitated, life sentence should not be imposed. So I think what this court discussed in Holman is really the best practice. And by that I mean, if the judge makes that finding on the record, we will know the judge considered what he or she was obligated to consider. The parties in the court will know that. If the case comes up on appeal, the reviewing court will know that. And finally, in Jones, the court made it very clear that the individual states can go beyond what the Supreme Court is requiring. So the court in Jones noted that individual states can impose additional restrictions or limitations on the imposition of a life sentence on a juvenile, and that states can even go so far, if they wish, to abolish life sentences on juveniles. And so it's up to states really to decide what findings need or need not be made. And so I would submit, Your Honors, that under Jones, what this court did in Holman, this court was able to do.
Counsel,
And what,
your time is up.
yes,
You're-
I apologize, Your Honor. For all of these reasons, Robert would ask Your Honors to adhere to Holman. Alternatively, if you don't, at least to make it clear to judges that the cases require the judges to consider those factors, even if they don't have to make a finding. And so respectfully, Robert asks this court to reverse the decision of the appellate court and to remand for a new sentencing hearing or additional post-conviction proceedings. Thank you, Your Honors.
Thank you, Mr. Fisher. Mr. Joshua Schneider?
Good morning, Your Honors. May it please the court, counsel. I'm Assistant Attorney General Josh Schneider on behalf of the people of the state of Illinois. The thrust of defendant's position is that Miller is unique and therefore exempt from the normal rules of waiver that govern negotiated guilty pleas. And the problem with that position is that although defendant invokes Miller, he does not actually raise a cognizable Miller claim because defendant did not receive a mandatory life sentence. He received a discretionary life sentence. He suggested that the court didn't actually have discretion or did not exercise sentencing discretion in this case because it was a fully negotiated guilty plea. But that misunderstands how the court's role in a fully negotiated guilty plea. The parties came forward to the court and they tendered a plea that they had reached between themselves. Their agreement did not bind the court. It did not compel the court to concur in that plea agreement and impose the sentence that the parties agreed was appropriate. What it did was ask the court to consider whether the court believed that that sentence was appropriate. And the court, everyone agrees that the sentencing range for the one count of murder that defendant was going to plead guilty to with the expectation of a 50-year sentence was 20 to 60 years. And everyone agrees that if the trial court did not believe that 50 years was the appropriate sentence for that crime, it had the discretion to reject the guilty plea. But here, the trial court considered the factual basis offered for the plea. It considered the fact that defendant was 16 at the time of the offense. It considered defendant's prior criminal history, and it determined that, in fact, 50 years was the appropriate sentence. And so it concurred in the plea, it accepted the agreement, it accepted the plea, and it entered the agreed-upon 50-year sentence. That is a discretionary sentence, and therefore is not governed by Miller. And because it's a discretionary sentence, it is subject to the same waiver that governs any challenge to a discretionary sentence as excessive. When a party enters a fully negotiated guilty plea, and he gets the discretionary sentence that he agreed to under that plea agreement, he is waiving any challenge to that agreed-upon sentence on the ground that it's excessive, whether under the Illinois Constitution, under the Eighth Amendment, an argument that is excessive because the court did not properly consider statutory sentencing factors or did not consider some other sentencing factors. That's a discretionary sentence, and he's waived any challenge to it by agreeing that it's appropriate. The argument that Miller still applies to discretionary sentences rests primarily on Holman. And the problem with that is that Holman is no longer good law in the wake of Jones v. Mississippi. Holman decided a tricky question at the time, because Holman was set with the task of reconciling Miller, which it had construed in People v. Davis as applying to mandatory sentences, with the new decision in Montgomery, which made Miller retroactive but included a lot of additional language. And in deciding how to interpret Miller in the wake of Montgomery, Holman recognized that there was a split in the authority. Some courts had come down on the side of construing Miller as applying only to mandatory sentences. Some had construed it as also applying to discretionary sentences. And faced with that split, Holman decided that it agreed with the cases that interpreted Miller as applying also to discretionary sentences. And it then further held that in applying Miller to a discretionary sentence, a court must consider evidence on the so-called Miller factors, the characteristics of youth that Miller discussed when explaining why youth is constitutionally significant in sentencing a juvenile homicide offender and therefore cannot be categorically excluded from consideration. And Holman also held that a court can't impose a life sentence without, after considering that evidence, finding that the juvenile offender is permanently incorrigible. That was Holman's position on the split that it faced, and Jones has now come down on the other side of that split. The Supreme Court has issued its controlling interpretation of Miller, and it is not the one that this court reached in Holman. And so Holman is simply no longer good law on those 3 points. Jones now has made very clear that Miller does not apply to mandatory sentences. All the Eighth Amendment requires is that the sentencing court have the discretion to impose a sentence shorter than life without parole, and that it not be prohibited as a matter of law from considering youth when exercising that discretion. What that means for our purposes in Illinois is that there cannot be a Miller challenge to a discretionary sentence in Illinois, because Illinois courts are...
Counselor, didn't that set out really only the federal limitation on sentencing young juveniles? And in Buffer, under our state constitution, provides greater protection. Isn't Buffer controlling here?
Well, Buffer was addressing the question of what a de facto life sentence was for Miller purposes. We determined that some term of years was sufficiently significant that it would be treated as a life without parole sentence. And the question before the court in Buffer was, what is that term of years? Buffer drew the line at 40 years. 40 years and less is not life without parole for Miller's Eighth Amendment analysis. Greater than 40 years was. But I don't understand Buffer to have issued a holding under our Constitution. Rather, it was drawing the line for Eighth Amendment purposes. Defendant has pointed out that Jones said that states are free to provide additional protections, but those additional protections have to be a matter of state law. We can't expand the protections beyond the limits that the U.S. Supreme Court has recognized in its Eighth Amendment jurisprudence. So in Illinois courts are not prohibited as a matter of law from considering youth. In fact, they are required to consider evidence of youth in mitigation because Illinois has long recognized that youth is a factor relevant to mitigation. And so courts are required to consider any evidence of youth that's presented to them in the same way that they're required to consider any evidence that's relevant to any other proper sentencing factor, aggravation or mitigation. So here we see the court actually did have evidence of youth before it. It knew that he was 16. That was in both the factual basis that was provided, as well as the court then confirmed after the conclusion of the recitation of that basis. It said, what was his age at the time of the offense again? And it was confirmed that it was 16. And then the court agreed, after being able to consider that information, that 50 years was the appropriate sentence, and agreed to impose that sentence within its sentencing discretion. Jones has overruled or abrogated Holman on those 3 points. Miller does not apply to mandatory sentences. Miller does not require any particular evidence on any of the factors that are discussed, the so-called Miller factors. In fact, if you look at footnote 6, Jones notes that even if somehow the court was totally unaware that the defendant was a juvenile at the time of the offense, that would not state a Miller claim. At most, that would be a claim that counsel was ineffective for failing to present mitigating evidence, in that case, mitigating evidence regarding youth. And finally, Jones has made very clear that there is no requirement for either an explicit or implicit finding of permanent incorrigibility for a court to impose a discretionary sentence of life. Now, defendant has argued that he couldn't have knowingly waived his rights under Miller because Miller hadn't been decided at the time. But again, the problem is he didn't have any Miller rights to waive because he received a discretionary sentence. So he didn't have a Miller claim. And what's left then is an Eighth Amendment challenge to a discretionary sentence on the ground that the sentencing court did not consider evidence of youth. The Supreme Court has not recognized that as a cognizable Eighth Amendment claim. It's not the normal gross disproportionality analysis that we apply to discretionary sentences, and it's certainly not a Miller claim because it's not a mandatory sentence. But it's exactly the kind of excessiveness challenge that you waive in Illinois when you enter a fully negotiated guilty plea. When a defendant in Illinois enters a fully negotiated guilty plea, and he receives the discretionary sentence that he agreed to, he's waived any challenge to that sentence as excessive. That's well established under this court's precedent in cases like Absher and Linder and Evans, and it's just a straightforward application of the basic contract principles that govern negotiated guilty pleas. If the people make sentencing and charging concessions, the defendant can't accept those concessions and then renege on the agreement by unilaterally seeking reduction of his sentence while keeping the people bound to their side of the agreement.
Can the defendant make an allegation that the sentencing scheme made his plea involuntary? I mean, that's what happened in Parker and Brown and some other cases, Robinson, some other cases. So the question, I realize the defendant in this case is really looking for a new sentencing hearing and not looking to withdraw his plea, but if we were to remand for the second stage proceeding, or for second stage proceedings, wouldn't the defendant be allowed to amend his pleading to show an involuntary plea?
So defendant doesn't seek to withdraw his guilty plea here. But to the extent that he's arguing that I didn't know that Miller would change the law, and therefore my plea at the time under the law as it was not knowing and voluntary, that's not a valid basis to challenge the validity of a guilty plea. In Brady v. United States, the Supreme Court explained that when we're looking at really it's not a challenge to the voluntariness, it's a challenge to the knowingness of the guilty plea. He's not suggesting that the state coerced him or threatened him. He's saying that had he known about Miller, he would not have entered this guilty plea. So he's really arguing that it's not a knowing guilty plea. And Brady explains that that's not how we analyze guilty pleas. Whether a plea is intelligently made is whether it was intelligently made under the law that was in effect at the time. In the same way that if we were evaluating whether counsel gave ineffective assistance by advising a client to accept a guilty plea, we wouldn't say that counsel performed efficiently by giving accurate advice under the law as it was at the time, because 19 years later there would be a change in the law that would make that, in retrospect, in hindsight, poor advice. Defendant made a reasoned decision, fully informed under the law as it was. That is a knowing guilty plea. And the fact that the law changed decades later doesn't retroactively render that knowing guilty plea unknowing. That's what Brady looked at, is basically in Brady, the defendant pled guilty to avoid a sentence that would subsequently be held to be unconstitutional, to be legally unavailable. And he said, well, that invalidates my guilty plea because I pled guilty just to avoid the sentence that I couldn't have gotten after all. That's this case. He says, I pled guilty to avoid a mandatory life sentence that we now know would have been unconstitutional. But that's not the sentence you received. What he received was a discretionary 50-year sentence that he agreed to after having been advised of everything he needed to know under the law at the time. To the extent that he wants to argue that he was not accurately advised about the law as it stood at the time of his guilty plea, that'd be an ineffective assistance claim, which he has not raised. So really, his argument is an argument in support of withdrawing his plea, not an argument in support of reforming the plea agreement to allow him to get the benefits of a subsequent change in the law while holding the people to their end of the bargain. That's why we point out that the remedy can't be just providing him relief on his side of the deal while holding the people to their side. Again, this is just the basic contract principles that govern guilty pleas, or negotiated guilty pleas rather, in Illinois. If a defendant is challenging his plea based solely on the sentence, if the people are willing to concede the benefit they were to receive under their agreed-to bargain and agree to resentencing, then that's an appropriate remedy. But if the people are not willing to concede their benefit, counsel's pointed out, no one could have understood this. This is a mutual mistake at the time. There's no fault on the part of the people. Why would the people be held to this agreement that they would not have entered into had they known that it was unlawful? Defendant says, well, he'd still be subject to a substantial sentence, and that may be true. But the benefit to the people was not merely the sentencing concession. Of course, the people also dropped murder charges. So the suggestion that all roads lead to resentencing is not exactly true. If defendant is resentenced on one murder charge, he'll receive a certain sentence, but the people will still not have received justice for the other victim. The people dropped that charge as part of their calculation about how they wanted to proceed. They decided that if he would plead guilty to one murder for 50 years, then they could forego seeking justice for the second victim. But if he's not going to get 50 years for that one charge, the people should not be bound to allow the death of that second victim to go unprosecuted. Similarly, if he is seeking to...
Simplistically, what you're saying is, if he gets any relief, it's going to be remanded to a do-over from the start.
No, we suggest that because he's only challenging to the extent he's challenging his guilty plea, he's only challenging the sentencing portion. He says the sentence I got is unlawful. If that were a basis to challenge a guilty plea, he's not actually trying to say, I want to withdraw my guilty plea. He's saying, I want to keep my guilty plea and I want a better deal on the sentencing. Well, if that's what he's seeking, the people are in a position to say whether they are willing to agree to give him the better deal that they're not obligated to give him, because of course they could say, we would not have entered in that plea in the first place, so we should return the parties to the status quo ante. But if they're willing to provide that relief to him, then they could agree to that. And there are circumstances where the state may not be in a position to recharge him, and so it would actually be unjust for him to say, my plea is valid, it was knowing and voluntary, the sentence is unlawful. So rather than allow the people to agree to correct the sentencing problem, I'm going to withdraw my guilty plea because now I know that the victims have died, or the witnesses have died, and so I can't be prosecuted for those crimes at all. The timeline of this case is a good example of why this could be a problem. The crime was in 1999. We are now in 2021. So decades have passed since this crime was committed. There are plenty of cases where that kind of interval will cause the case to no longer be prosecutable, not because of a statute of limitations period, simply because of the evidence becoming unavailable. And so there are circumstances where the people might say, if we can agree to the sentence that you want, then you should not be allowed to withdraw your guilty plea and effectively have run the clock out on these charges by agreeing to this sentence, waiting 21 years, and then challenging the sentence alone and getting this windfall of not getting prosecution at all.
Well, it's because Miller's come about that this is being raised in front of us, correct?
It is, and again, this isn't actually a Miller case. This case doesn't present the question of whether a defendant who entered a negotiated guilty plea in exchange for a mandatory life sentence would have waived that challenge, because he got a discretionary sentence. So we aren't really confronted with a question of would a mandatory sentence, if you think of cases back when the 25-year firearm enhancement was mandatory, there were guilty pleas where someone would plead guilty to the minimum sentence, which was a de facto natural life sentence. That would be a Miller claim, because the only sentence available was a mandatory life sentence. So the court, in accepting that negotiated guilty plea, had no discretion to impose a sentence shorter than life, because the range was 45 to 85, I suppose. But this case doesn't present that question. Frankly, I don't know that question will ultimately be raised. My understanding from having reviewed the appellate court decisions is that generally a defendant who brought a claim that he'd received a mandatory life sentence has received relief on that claim. So I don't know that there will be further litigation on this issue after this, but all we're faced with here is the question of whether a discretionary life sentence invalidates a guilty plea or is unwaivable because it invokes Miller, and the answer is no. It is not a Miller claim. It is just a challenge to a discretionary sentence as excessive. And that is exactly the kind of claim that is waived when you enter a fully negotiated guilty plea. And if you look at the character of the claim, he's saying that it violates the Eighth Amendment because the court did not consider a sentencing factor, specifically youth. But that is exactly the kind of claim that you waive, and it's explicitly the claim that he waived on the record. If you look at page R64, defense counsel explicitly waived any hearing on evidence in aggravation and mitigation and expressly waived any PSI. So you can't tell the court, I'm not going to present you, I'm waiving the right to present any evidence of youth, and then fault the court for not having considered evidence of youth.
Of course, Miller was unknown at the time of this plea, right?
That's right, but the significance of youth as a mitigating factor was known, because that had long been established as a matter of Illinois law. So he already knew that youth was mitigating. He just didn't know that youth was constitutionally required to be considerable by a court before imposing a de facto or actual life sentence. And for those reasons, and the reasons in our brief, unless there are any further questions from the court, we would ask that this court affirm the judgment of the appellate court. Thank you.
Thank you, Mr. Schneider. Mr. Fisher?
Your Honors, the state says this is not a Miller case. This case is most definitely a Miller case. It's also a buffer case. There are other aspects to it, but it is clearly a Miller case because Miller tells us that what happened in this case cannot stand. Miller tells us that only a relative minority of juvenile offenders should receive life sentences. Why? Because most of them can be rehabilitated. Most of them, as they get older and mature, will, so to speak, grow out of their criminal conduct, grow out of their criminal ways. Miller tells us that in trying to make that difficult decision, not saying it's easy, but in order to make that difficult decision, which juveniles are so bad that they should receive life and which juveniles should not receive life, that there are certain things a judge must consider, such as the offender's youth and the attendant circumstances of youth. All of those things must be considered by the judge at a discretionary sentencing hearing. Now, the state argues, well, he already received a discretionary discretionary sentencing hearing. Your Honors, of course, know the difference between an open plea hearing and a negotiated, especially a fully negotiated plea hearing. The state says, well, even back then, youth was a mitigating factor in Illinois, and the judge noted that the minor was 16. I've cited several cases in the briefs where reviewing courts have said in light of Miller that just is not constitutionally sufficient. Yes, he knew he was 16. Did he consider the attendant circumstances of youth? Just like de facto life sentence was not part of our lexicon back then, neither were the attendant circumstances of youth. Now, sure, there could be a given case in which the trial judge, pre-Miller, pre-Buffer, might have gone into some of those things, but clearly that did not happen here.
Counsel, could you respond to the Attorney General's arguments that our Miller analysis that we have been doing here in Illinois, and of course everyone has across the country, has been changed significantly by the recent United States Supreme Court case in Jones. How do you read Jones? How does that impact Miller, and how does that impact the earlier cases here in Illinois?
The majority in Jones, according to what the majority says, sought to interpret Miller, made very clear it was not departing from Miller, was not overruling Miller or Montgomery, merely sought to interpret and apply the plain language in Miller. In fact, it's interesting, the dissent in Jones accuses the majority in Jones of departing from at least the spirit and intent of Miller. On the other hand, the majority in Jones accuses the dissent of trying to read language into Miller that's not there. So the court in Jones very plainly reaffirmed these core principles announced in the Miller case.
It certainly narrowed them to application in cases where sentencing was mandatory rather than discretionary, correct? Isn't that what Jones did?
Well, what Jones and Miller both make clear is that any or every life sentence imposed on a juvenile is unconstitutional unless the judge holds a discretionary sentencing hearing, a hearing in aggravation and mitigation, considers the offender's youth and the attendant circumstances of youth, and whether or not that minor falls into the very relatively, it says relatively rarely, relatively small category of juveniles who should receive life sentences. And so I think the clear takeaway from Miller, Montgomery, and Jones is that a mandatory life sentence is unconstitutional because it doesn't allow the judge to exercise that discretion. And a discretionary life sentence is also unconstitutional unless the judge considers youth and its attendant circumstances. Now, the state notes that the defense here waived that hearing in aggravation mitigation, waived the pre-sentence reports. Well, as your honors know, that's what usually happens in a fully negotiated guilty plea. Another important thing, again, the state says discretion was exercised here. I think it was very limited discretion in terms of deciding whether or not to take the plea. But even if your honors say, well, that's some discretion, it certainly was not the type of hearing envisioned or expected by the court in Miller, Montgomery, and Jones. Furthermore, if the judge exercised, or to the extent perhaps that he exercised discretion saying 50 is appropriate, we must remember that when he did so, he had no idea that 50 was de facto life. Again, de facto life wasn't even part of our legal terminology at that time. Furthermore, he knew, he was told the charges that were being dismissed. And so he no doubt considered the fact that this individual, had the charges not been dismissed, would have gotten life, probably considered this was a major benefit. If he exercised discretion, he exercised discretion through the lens of what we knew and what we thought about, or judges knew and thought about back then, not what judges must consider now. To the extent that the state says, well, and I don't want to be flippant, but it sounds like the state is saying, well, any old type of discretionary sentencing hearing is good enough. I think the danger there is we're going to go back pre-Miller and pre-Buffer, because there were plenty of discretionary sentencing hearings, aggravation and mitigation, and life sentences were imposed on juveniles. And Miller and Jones make clear that is no longer constitutionally sufficient. And so that is why
given the nature of these multiple charges in this case, if this case were remanded, how broad would the remand be?
Well, again, if this court remanded, the court could remand for resentencing. The court could remand for additional post-conviction proceedings. If it's a new sentencing hearing, if you're asking sentencing parameters, again, the Minor submits he's not seeking to withdraw the plea, and so he should be sentenced on the charges that were before the court that he had admitted to at the time that he pled guilty, which is 1 count of first-degree murder, 2 counts armed robbery, 1 count of home invasion. And I had forgotten, counsel for the state says to your honors today that he was admonished at that time that the limit or the upper part of the range was 60. Again, that right there is what, 20 years over de facto, so it's certainly very serious penalty range. State says there's no justice for the second victim. There was an armed robbery count pertaining to the second victim to which he pled guilty. Certainly, at a sentencing hearing, even if charges have been dismissed, there's no question the state can't present evidence with respect to the other criminal conduct and present evidence as to the second murder. I think there's individuals can differ. I think that's a bit of an overstatement that the state makes. Again, if this court believes that the only appropriate relief is withdrawal of the plea, then I guess so be it, although that is not the relief that Robert is requesting. Just very briefly,
Thank you. Mr. Fisher, your time?
I'm sorry.
Your time?
I'm sorry. Thank you for your consideration, Your Honors. In short, this court should reverse the decision of the appellate court, and it's very clear from the state's brief, they're not conceding that. They talk about, well, maybe we'll agree to some other sentencing relief. Their primary argument is this court should simply affirm that decision of the appellate court violated the Eighth Amendment. It deprives Robert of those evolving standards of decency for no good reason. Robert respectfully asks this court to reverse the judgment of the appellate court and to remand either for resentencing or additional post-conviction proceedings. Thank you, Your Honors.
Thank you, Mr. Fisher. Case number 126432, People of the State of Illinois versus Robert Christopher Jones, will be taken under advisement as agenda number 23. Thank you, Mr. Fisher, and Mr. Mayor, for your arguments this morning.